Welcome back. Public Protector Advocate Busisiwe Mkhwebane has unreservedly apologized to Judge Sulett Potteril. Mkhwebane had accused the judge of omitting the words executive ethics code in a ruling she gave in favor of Public Enterprises Minister Pravin Gordhan. Then head of SARS, Karyn Maughan, is a senior legal journalist at News 24. She joins us now to discuss it. So let's just backtrack a bit and give a bit of context to why this apology is important and what makes it unreservedly, if there's certain aspects that she doesn't agree with, the public protector, that is.
Well, essentially what happened today was that the public protector and the EFF have sought to appeal a judgment given by the full bench in the High Court in relation to its invalidation of her so-called SARS rogue unit report. And as part of that judgment, the full bench had taken a very sort of sharp view on her criticism of Judge Sulett Potteril, who of course was the judge who initially interdicted the implementation of the remedial action against Pravin Gordhan, ultimately that he faced some form of disciplinary action from the president. And in court papers, Advocate Mkhwebane accusing the judge of deliberately omitting the words inadvertent from the Executive Ethics Code in relation to this finding that she'd made that Pravin Gordhan had inadvertently misled Parliament about meetings that he may have had about an engagement in which a Gupta family member had been present. And Advocate Mkhwebane insisting that the word inadvertent was in the act, in the code, when it was in fact not in the code, and making this very serious contention that the judge had deliberately almost taken it out for reasons which would obviously be not explicitly stated. But the court very unhappy over that, saying that she had to apologize and referring its report, its judgment, to the Legal Practice Council for its consideration in terms of the ethical nature of what the Advocate Busisiwe Mkhwebane had done. So she has, in this appeal, which was heard today, which is her and the EFF seeking to challenge the invalidation of the SARS report, saying, look, she's not challenging, she points out that there was a 2007 version of the code, which she, may have mistakenly referenced at the time, but she does unconditionally apologize for her comments on the judge's, interpretation, as she puts it, of the Executive Ethics Code. But she also insists that Pravin Gordhan must be forced to apologize to her for saying that she was incompetent and didn't actually have a grasp of the law.
Now, Karyn, there's what has been argued by her legal representatives, including herself, first of all, finding the cost of 15% against her personally as ridiculous, not necessarily in those words. I'm paraphrasing here, but the fact that the judgment itself was considered as institutionalized judicial bias. Take us through those.
Well, this, we know that there have been a number of personal cost orders issued against the public protector. The first, most notoriously, in the Reserve Bank matter, which was upheld by the Constitutional Court, which found that she had acted in bad faith in terms of the investigation and compilation of the report and the subsequent litigation, hadn't disclosed so-called secret meetings with the State Security Agency and the presidency over that very far-ranging, remedial action against the Reserve Bank. That was the first case. Personal cost order against her in the Estina matter. But in other cases, including her battle with SARS Commissioner Edward Kieswetter over Jacob Zuma's tax returns, the Constitutional Court said that it was inappropriate for the lower court to have awarded a cost order against her, and potentially part of a worrying trend where she was, being saddled with cost orders without proper reasons being given for that. Now, in order for a personal cost order to be granted against you as an official, you really need to display manifest bad faith, dishonesty, and very problematic litigation style in order for that to happen. So what she's now said, her lawyers are saying in this application in relation to the rogue unit, they're saying that that's one of these cases that, even though she made these comments about Judge Sulett Potteril, and the court found that she had an improper political motive in producing this report, they dispute that motive exists, and they also say there's no basis on these reasons, which they claim are false, to order her to pay 15% of the legal costs in this case. And they're saying there is this adverse trend from the Pretoria High Court, and that any cost order granted against her from that court needs to be treated with suspicion.
Now, there's another point that was made by her legal team, which is also quite intriguing, saying that she could be accused of all things, but she could not have anticipated that the former Inspector General's report, for instance, in General of Intelligence, Faith Khateba's 2014 report, would be set aside. How does that fit into this whole milieu?
Well, essentially what she's saying is that, her report was based on the inputs of, amongst other people, Musi Sikakani, Judge Karyn, the KPMG report, and the Office of the Inspector General of Intelligence report, which was subsequently, as we know, set aside in a separate proceeding by Johan van Lokrenberg. And she's saying that, while the court found that all of those sources had either retracted or were discredited, this was not necessarily the case. And she's saying that she did make, she cannot be held, accountable because there's now this situation where some of these issues and reports are disputed. She specifically says that Musi Sikakani's report has never been set aside, and therefore it's problematic to say that it has been discredited. Of course, Pravin Gordhan's lawyer is saying that essentially that Karyn has withdrawn, KPMG has withdrawn. There's no substantive evidence behind that, and the State Security Agency has also chosen not to try and the office, to support that IGI report by Faith Khateба. So it's really about her saying, look, I didn't just make this up out of nowhere. There were these things that I considered, but Pravin Gordhan's lawyer is saying these are actually not, factually based sources of information, and it's not a defense against what is clearly an unlawful and improperly motivated report.
So, Karyn, just to wrap up this aspect of it, so the public protector and her legal team want the Supreme Court of Appeals to have a final say on the rogue unit matter, because she's saying that at the heart of it is that the judges who made the ruling made errors in fact, law, and misdirections.
Well, essentially, when you take a case to the SCA, you need to be able to show that there's a reasonable prospect of success on appeal, and also that there's a potentially novel legal grounds being raised. One of the grounds that she is raising, of course, is this issue of jurisdiction. She has a 2-year period after which an alleged offence has taken place, or maladministration, in order to investigate. The SARS rogue unit matter obviously dates back quite a number of years. And she, the court ultimately found that she did not present any special circumstances why she should do that investigation. So she's saying that she believes she did provide evidence in relation to certain surveillance equipment that may have been bought at taxpayers' expense, and she believes the court should look at this issue of her jurisdiction in terms of investigating matters that predate that 2-year limit. So she's basically trying to make that kind of argument, and also making arguments that she believes that her report was justified on the sources of the information before her and was rational, even though those sources may be subject to some form of scrutiny and challenge.
Okay.
So, but ultimately, it's about, are prescient legal issues being raised here, and is there a prospect of another court coming to another conclusion? Gordhan's lawyer is saying that's simply not the case, and her appeal application should be dismissed.
All right, so just finally, I know that you're out and about this evening. You've been attending the JSC hearings, the interviews into the 2 vacancies at the Western Cape High Court. And when we were speaking just off air a short while ago, you said there was a very interesting exchange between the Chief Justice Mkhwebane and the EFF leader Julius Malema. What exactly was it about?
Well, essentially what happened was that the Chief Justice played a voice note that had been put on a magistrate's WhatsApp group by the Chief Magistrate of Cape Town, Daniel Tulare, who is one of the 6 candidates for these positions, in which he, sang a song, a sort of political song, but basically said that the judiciary was rudderless and bleeding, and that, suggesting very strongly that it needed to, appeal court president Mandisa Maya should be put at the helm of it as the next Chief Justice. And Mkhwebane asking him whether the song he was singing was a political song or was it used by President Cyril Ramaphosa's campaign, which he denied. Malema then interjected and said that, accused the Chief Justice of quote unquote ambushing Tulare and saying, this isn't right, etc. Mkhwebane then pushing back and saying, well, this WhatsApp was sent to, the voice note was sent to everyone. It's not an ambush. He knew about it. He was given notice, and very much disputing that. But of course, in the context of what happened with Daya Pillay, with the Chief Justice confronting her about this issue of her meeting with Pravin Gordhan, it is somewhat interesting now that, the EFF leader is confronting him about an ambush which did not occur because everyone was given notice. But, in the preceding incident, no such notice as far as we know it wasn't.
And of course we'll see how that all plays out, Karyn, because we know that last year, I think it was in October already, the Chief Justice Daniel Tulare himself had a fiery exchange with the Chief Justice for these very interviews. Thank you so much, senior legal journalist at News 24, Karyn Maughan.